Welcome to the Cuffs and Case Law Podcast, where we read case law so you don't have to.
Today, we are talking about another absolutely foundational and landmark case which forever altered policing in this country. And that case is Miranda v. Arizona.
That's a big one.
It's a big one from 1966. So Miranda v. Arizona established the famous and often misunderstood Miranda warnings, with which the majority of people, not just cops, are at least vaguely familiar. So who is Miranda? What exactly are the warnings? And when are the warnings required to be given? For the answer to those questions and much, much more, stick around and stay tuned because we're going to dive deep and get into the nuts and bolts of this case. I'm Nate. This is Dave. We're cops. We're not attorneys. All right. You ready for this, man?
Yep, let's do it.
All right. So the majority of policing in the United States is governed by the Fourth Amendment to the Constitution of the
You've
United
made that
States.
abundantly clear so far.
Good. So this case, however, is a little bit different. It primarily deals with the Fifth and the Sixth Amendments. Now, don't worry. That's not one of my warpaths. I'm not going to make you quote the Fifth and the Sixth Amendments.
You can't have that many warpaths.
No. I have quite
That'd
a few
be battle
warpaths.
paths at that point. Yeah.
But since this one deals with the Fifth and Sixth Amendments, and we've harped a lot on the Fourth Amendment, and we're going to continue to do so, we have to set a little bit of foundational knowledge to ensure that we're all singing from the same sheet of music. So, the Fifth Amendment to the Constitution of the United States says,
There's so many amendments to the Constitution, but if I can only pick one, Fifth. Dave Chappelle reference right there. I cut you off.
All right. The Fifth Amendment to the Constitution of the United States says no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So there's a lot in there. There's a lot of rights that are outlined within that Fifth Amendment. But the one that we're focusing on primarily today is where it says, quote, nor shall be compelled in any criminal case to be a witness against himself. This is commonly referred to as the right against self-incrimination. So you cannot be forced by the government to testify against yourself in a criminal case. That's what we're talking about. So Fifth Amendment's a big one for what we're talking about today. And we're also talking about the Sixth Amendment to the United States Constitution.
I don't have any fun things for that one.
Yeah.
Dave Chappelle didn't cover it.
Okay, fine. I guess I'll just read it. All right. The Sixth Amendment to the United States Constitution says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So for this one, again, we're talking about, there's a lot that's outlined in there as far as your rights, but we're talking about the last one where it says, quote, and to have the assistance of counsel for his defense. So Miranda v. Arizona, every single cop out there understands Miranda warnings and knows that it comes
unless you're on 21 Jump Street.
Know that
you say you have the right to be an attorney? Well, you do.
So all cops know that it comes from Miranda v. Arizona. But not talking about the warnings themselves, what do you know about the case of Miranda v. Arizona, just off the top of your head?
Not much.
Yeah.
I don't know that we really ever covered much of it. Obviously significant enough to cause the case law that came after it, but
yes.
Yeah, the actual facts and circumstances, I don't think
And I don't think a lot of cops do. I don't think a lot of people do. I like to consider myself a bit of a case law nerd. And
you are.
I would be lying to you, dear viewer, if I told you that I knew everything that I learned while I was researching this. I always learned something, but I learned quite a bit while researching this one. So
That's why
hopefully you will too.
I say that's why you come to the Cuffs and Case Law
Yeah, exactly.
long form podcast.
Yes, the long form. All right.
So you get all those facts and you can be super cool and nerdy like Nate.
I'm not that cool. Nerdy, sure.
Mm-hmm.
All right. So one of the biggest things that I don't think the majority of people understand is that the case of Miranda v. Arizona was actually a consolidation of 4 separate cases by
Of
the
course
United
it
States
was.
Supreme Court. So if you remember,
I assume you're only going to go over one of those.
No. So if you remember from Peyton v. New York, that was 2 cases that were consolidated at the same time because they were making the same argument, right? Both Peyton and Riddick. So it's called Peyton v. New York, but it's actually answering 2 separate cases. Well, Miranda v. Arizona is actually a consolidation of 4 cases, but all of these cases involve police interrogations and confessions which were obtained without proper warnings given ahead of time. So the 4 cases that we're going to be talking about today are, believe it or not, Miranda v. Arizona.
That sounds right.
Yeah, that's one of the 4. Viniera v. New York, Westover v. United States, and California v. Stewart. So all 4 of these cases raised the exact same constitutional issue, and that is whether a suspect's Fifth Amendment right against self-incrimination was violated during custodial interrogations. So the Supreme Court ultimately combined them into one decision, and that decision outlined a requirement that the police must inform suspects of their rights within certain circumstances, and we now call those Miranda warnings because of this case.
And we capitalized Miranda and warnings.
Yeah, we sure do. All right. So we're going to go, to my chagrin, I cannot go into excruciating detail into each of these cases because this would be a 14-hour episode.
We can barely hold on to people for 10 minutes.
But I will go a little bit into each of these cases so we have a little bit of understanding of how we got where we got. So starting with Miranda v. Arizona, in 1963, Mr. Miranda, Ernesto Miranda, was arrested in Phoenix for the kidnapping and rape of an 18-year-old woman. So he was arrested at his home, and he was taken into custody to a police station where he was picked out. He was identified by the victim, the complaining witness. He was then interrogated by 2 police officers for 2 hours. And at the end of that interrogation, it resulted in a signed written confession by Miranda. So at the trial, the oral and the written confessions were presented to the jury, and Miranda was found guilty of all the charges that were levied against him, and he was sentenced to 20 to 30 years.
So he went to trial even though he had confessed?
Correct. So he was sentenced. He was convicted. Now, believe it or not, his attorneys appealed. And on his appeal, it made its way up the course to the Supreme Court of the state of Arizona, which held that Miranda's constitutional rights were not violated in obtaining the confession. So that's what the Supreme Court of Arizona said. So important things to point out is that during this interrogation, Miranda was not informed of his right to remain silent. He was not told that he had the right to have an attorney with him, and he did not have a lawyer present. Interestingly enough, his the written confession that he signed had a portion at the top that said, "Hey, this confession's totally voluntary."
Doesn't sound like it was.
Yeah, so there was no evidence presented that he had been advised of his constitutional rights beforehand.
He didn't write under protest somewhere on it?
No, he didn't actually. I haven't seen that in a long time.
I love it.
Under duress.
Yeah.
So that is the very basics, surface level of Miranda v. Arizona. So the next one is Viniera v. New York, which involves the arrest and interrogation of Michael Viniera.
Michael.
In 1960, Viniera was arrested in New York City on suspicion of robbery. Because it's always robbery. It's always robbery.
It's robbery.
What?
Cuffs and Case Law robbery podcast.
Cuffs and Case Law. I swear, so much case law is made off robbery charges.
You would think it'd be like murders, but no.
Well, hold that thought.
Okay.
So Viniera was picked up by New York police in connection with a robbery of a dress shop. So I don't know if he was robbing dresses.
You sure it's not Michelle?
It's Michael.
Okay.
So I don't know if he was robbing the dresses or the proceeds gained by said purveyor of dresses.
He probably couldn't buy those freely, socially, as he can now. You should have just waited. It would have been okay.
So the New York Police Department arrested him for robbery 3 days after the robbery occurred. He was first taken to the 17th Detective Squad headquarters, and then he was taken to the 66th Detective Squad, where he verbally admitted to the robbery, and he was placed under formal arrest at that point in time. So from there, he was taken to the 70th precinct.
Why?
For detention. And there he was questioned by the assistant district attorney in the presence of a hearing reporter who transcribed the questions and the answers.
They just running through the entire investigation in a few hours.
Yeah, they're just knocking it all in one foul swoop. So at his trial, the verbal confession and the transcript were presented to the jury. And believe it or not, he was found guilty of first-degree robbery, and he was sentenced to 30 to 60 years.
Woo. Then dresses weren't worth it, buddy.
Yeah, no, not even a little bit. So, believe it or not, he appealed and said that his Fifth Amendment rights were violated. And it made its way through the court process, and the appellate division and the Court of Appeals both affirmed without opinion. So another way of phrasing that is your favorite in the world, which is that they affirmed
the denials.
Yes. So again, same sort of thing as Miranda. He was taken into custody and interrogated, never advised of his rights. Made his confessions. Those are used against him. He says, hey, you can't do that. That violated my Fifth Amendment right. Third case is Westover v. United States, which involves the prolonged custodial interrogation of
they're getting longer.
Carl Calvin Westover. So also in 1963, Mr. Westover was arrested by local police in Kansas City as a suspect in 2 Kansas City robberies. Yeah, it was robberies again. And he was taken to a local police station. While he was at the police station, a report was received from the FBI that Westover was actually also wanted on a felony charge in California.
For robbery?
Yeah, it was robbery.
Serial robber.
It was also robbery. So, arrested in Kansas City. He was interrogated on the night of his arrest by local police and the next morning again by local police. So then once the FBI agents figured out that he was in custody, they go to Kansas City, and they continued the interrogation of Mr. Westover at the station.
Everyone wants a piece.
Everybody. So after 2.5 hours of interrogation by the FBI, Westover signed separate confessions, which had been prepared by one of the agents during the interrogation, to each of the 2 robberies in California. And those statements that he signed were introduced to him at trial, and he was convicted of the California robberies and sentenced to 15 years imprisonment on each count.
Ooh.
So, believe it or not, Mr. Westover appealed, saying,
I don't want to do 60 years.
Yeah. But also, well, it'd be 30 years, 15 years on each. 2 counts.
We don't know.
I don't know.
We don't know what happened in Kansas City.
No, because they snatched him up on the California charge.
They said, we're the FBI and we got this.
This is ours now. So he appealed just like everybody else. And the conviction was affirmed by the Court of Appeals for the Ninth Circuit. Again, same exact details. He's arrested. He's interrogated by local police for about 14 total hours.
Oh, man.
He was interrogated. The interesting thing about this one is, remember, he was interrogated by the local police first before the FBI. So when the FBI came in, they actually did provide him a warning about his right to remain silent. But this only came after he had already been interrogated for an exceedingly long time. And all of those statements were used to convict him.
He's like, I've already talked for 10 hours.
Yeah, he's exactly
or whatever.
Right. All right. And the last one is California v. Stewart, which involves the interrogation of Roy Allen Stewart, also in 1963. So 3 of these are in 1963. Stewart's arrested in Los Angeles after they were investigating a series of purse snatching robberies. Yeah, it was robberies again. But this time, one of the victims died of injuries.
Ooh, that was a very violent robbery.
Inflicted by her assailant.
Ugh.
So
that has a different name.
Yeah, but there's that robbery we told you to, or that murder we told you to put a pin on. So Stewart was identified as the endorser of checks that were stolen in one of the robberies.
It's a bold move.
Yeah.
Cashing checks of a dead
Yeah, so
lady.
this one continues to get interesting. So Stewart was arrested at his home, and police also arrested his wife and 3 other people.
Guilty by association.
Yeah, so his wife and 3 other people who were visiting him also get arrested.
Bad time for the family trip.
Yeah. So Stewart's placed in a cell, and over the next 5 days, he is interrogated on 9 different occasions.
Oh, man.
Yes. So during the 9th of the interrogation sessions, Stewart stated that he had robbed the deceased woman, but he had not meant to hurt her.
Never do.
So at that time, the police released the 4 other people that they arrested because there was no evidence to connect any of them with any crime.
Did they get interrogated 9 times?
It doesn't say, but it sounds like old Stewart eventually fessed up to everything. So at his trial, all of his statements, his incriminating statements that he made against himself, were introduced. He was convicted of robbery and first-degree murder, and he was sentenced to death.
Ooh.
Yes. So this is the first case we've covered where one of the plaintiffs was given the death penalty as a sentence.
Might want to try to appeal that.
Now, here's the interesting thing. He does, right?
Yeah.
Because of course he does. That's how we make case law. But the Supreme Court of California reversed the conviction, holding that Stewart should have been advised of his right to remain silent and his right to legal counsel.
Do you think if they'd only questioned him 9 or 6 times instead of 9, it would have been?
No, I don't think it would have been any better. All right. So that is a surface level, high level overview of each of the 4 cases. And again, as we mentioned earlier, all of these cases ask the exact same question. And if you think about it, we're literally spanning the entire continental United States. We have California all the way to New York, and we have differing opinions within the 4. And we obviously have pretty strong constitutional questions here.
So we have high stakes.
Yes, that's how it makes it all the way up to the Supreme Court. So,
how long did it take to render this decision?
A couple years. Yeah. So the majority opinion for this case was delivered by Chief Justice Earl Warren.
Our buddy Earl.
Old Earl. So we're still in the Warren court, just like we were for Terry B. Ohio.
Now, again, speaking of Terry.
Yes.
Was he the coaching put himself in?
You better believe he did.
Old Earl. I don't know if he did it a lot, but he sure nailed the big ones.
Yeah, he sure did. He whenever it was going to be a titan of a case, old Earl wanted to write it himself as the Chief Justice, so he did.
Hey, if you want the job done right, you do it yourself.
So, now this one,
I have to put a picture of Earl behind me.
Old Earl. So Chief Justice Warren is the one that wrote the majority opinion for the court in this. Now, this is kind of interesting because remember, there's 9 justices on the United States Supreme Court. And this one was an interesting split. So you had 5 concurring justices, 3 dissenting justices, and 1 who split the fence. He concurred in part and dissented in part.
How do you get away with that?
Because he can say, look, I agree with this part, but I disagree with this part. And that's what he did. That guy was Tom C. Clark was the justice who both concurred and dissented.
I feel like you got to make a decision here, buddy.
That's kind of his job, just to make his decision.
I don't know how. I feel like Earl would kick him off after that, saying, we're done with you. You're no longer needed here. Pack your bags.
So, all right. So, Chief Justice Warren starts with an opening statement in their decision here. And he said, the cases before us raise questions which go to the roots of our concepts of American criminal jurisprudence. The restraints society must observe consistent with the federal Constitution in protecting individuals from crime. More specifically, we deal with the admissibility of statements obtained from an individual who is subjected to custodial police interrogation and the necessity for procedures which assure that the individual is accorded his privilege under the Fifth Amendment to the Constitution not to be compelled to incriminate himself. So immediately after that, the Supreme Court says, look, we just kind of dealt with a lot of these questions 2 years ago in a case called Escobedo versus Illinois.
You haven't covered that one yet.
We have not, no. But we're going to real briefly right now because it's pretty similar. So, and that's the whole point of them bringing it up is like, hey, there's a lot of things that we already addressed a couple years ago that are going to be important to this case too. So, in the case of Escobedo versus Illinois, the police did not effectively advise him of his right to remain silent or his right to consult with an attorney. Rather, this is pretty clever. Uh, the police confronted him with an alleged accomplice. That accomplice accused Escobedo of having perpetuated a murder.
Here, let's put you two in the room and you guys fight it out.
So
we'll just watch.
So then Escobedo's like, I didn't shoot, man. Well, you did.
Ooh.
So they handcuff him and they take him into an interrogation room. There, while handcuffed and standing, he was questioned for 4 hours.
He had to stand for 4 hours? Well, that's it.
Correct. Handcuffed and standing for 4 hours until he's...
That's not a great look.
It gets worse, ready?
Oh, no.
During this interrogation, the police denied his request to speak to his attorney. It gets worse. And they prevented his retained attorney, who had come to the police station, from consulting with him.
Oh, boy.
Yeah, not good. Not a good look. So at his trial...
Where was this?
What's that?
Where was this?
Illinois.
Yeah.
So at his
trial... He done
trial...
messed up on that one.
Yeah.
Real bad.
The state introduced his confession against him, and the Supreme Court made it all the way to the Supreme Court, and they said, no, those are absolutely constitutionally inadmissible. So again, there's a lot of similarities here. Now, there's reason that they couldn't just rely on that alone. There's enough differences here. But they start off by saying, we just talked about this. And not this exactly, but this pretty close. And so we're going to use that as a diving board to jump forward.
Ooh,
but then,
jump down. You dart forward and down, I guess.
Yeah, it's both, right? All right. Then old Earl does something that is super rare for the Supreme Court. It is super convenient for cops and everybody else reading.
Gives you a quick summary.
He gives you a cuffs and case law style summary.
Outstanding little TLDR line for us.
He does. He straight up gives you a TLDR.
Thank you, Earl. See, I'm leaning more towards Earl's going to be my background.
Yeah. Well, just stand by.
Oh, great. All right. Stand by with us to see if I still want Earl behind me.
Earl has some really strong opinions about the police.
No wonder he's putting himself in on this one.
Yeah.
Although he probably should have, at least he has an opinion.
Yes, and his opinions are rooted in his historical fact. So it's real hard to argue with him.
Yeah.
We have to preface this. So I am very glad as a citizen and as a police officer that policing in this country has made big strides in the last 100 years, in the last 70 years, in the last 60 years. And we'll talk about that here in the future, but I think Chief Justice Warren would be pleased with where policing is now, whereas a lot of the things policing at the time he was not super pleased with.
I'm not pleased with these discussions. with what they're doing again. Bad facts make bad case law.
They sure do.
And what you've described is not good.
Yeah, exactly.
So I get why old Earl's going to be pissed.
He is. All right. So right before his TLDR, he says, it was necessary in Escobedo, as here, to ensure that what was proclaimed in the Constitution has not become but a form of words in the hands of government officials. So kind of like in Terry, remember, he's like, hey, the Constitution's got to have teeth. If it doesn't have teeth, then it's pointless, right? And he says, our holding will be spelled out with some specificity in the pages which follow. But briefly stated, it is this.
Oh.
So he straight up says TLDR.
I'm about to write a lot, but you can just skip to this part.
He's like, I'm going to go into excruciating detail. But if you want the TLDR, if you want the nuts and bolts, here it is.
Nice.
So the prosecution may not use statements, whether exculpatory or inculpatory. So exculpatory evidence is evidence that's favorable to the defendant in a criminal trial, and it either exonerates or tends to exonerate the defendant of guilt. And it's the opposite of inculpatory evidence, which tends to present guilt. So the prosecution may not use statements, whether exculpatory or inculpatory,
Exclude or include?
Exclude or include stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. Next point. By custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way.
Do they define significant?
Not specifically, no.
Of course.
But some other cases help explain what that looks like. As for the procedural safeguards to be employed, unless other fully effective means are devised to inform accused persons of their right to silence and to assure a continuous opportunity to exercise it, the following measures are required. 1. Prior to any questioning, the person must be warned that he has a right to remain silent. 2. That any statement he does make may be used as evidence against him. And 3. That he has the right to the presence of an attorney, either retained or appointed. The defendant may waive effectuation of these rights, provided that the waiver is made voluntarily, knowingly, and intelligently.
Do they define intelligent?
No. If, however, he indicates in any manner and at any stage of the process that he wishes to consult with an attorney before speaking, there can be no question. Likewise, if the individual is alone and indicates in any manner that he does not wish to be interrogated, the police may not question him. The mere fact that he may have answered some questions or volunteered some statements on his own does not deprive him of the right to refrain from answering any further questions until he has consulted with an attorney and thereafter consents to be questioned. So there it is. There's the TLDR. If you want a base level light understanding of Miranda, there it is. That's what it is. Now,
thanks, Earl.
Yep. So Chief Justice Warren lays it out just like that. But as we do in cuffs and case law, we're going to dive deep because the context matters, right? The context matters, and I love to.
You're stealing my tagline.
Sorry. I know that's yours. That's one of your favorites.
I stole drink more water.
But it's important to me to understand why they came to the decision that they came to. That helps give you a more complete understanding of the case in its entirety, the way the Supreme Court thinks, things that you should be thinking of, right? All right. So in justifying the reasonings that they just laid out, the Old Earl and the Supreme Court actually break it down into 5 separate sections.
Ooh, 5.
Yeah, I know. So bear with us because we're going to get through all 5 sections. But it kind of makes a lot of sense and it helps justify why they made the decisions that they made. So they start off by giving a little bit of historical context. So have you ever heard the phrase giving somebody the 3rd degree?
Nope.
No. All right. So
that sounds made up.
It's a common phrase.
I don't think it is.
Not like grains of
Leave it
sand
in the
or whatever I
comments
said.
below if you have ever heard of giving someone the 3rd degree. And if you're under the age of 65.
I am a 78-year-old man and a 22-year-old body.
At least 69.
So giving somebody the 3rd degree is like referring to intense and super aggressive types of interrogation. Oftentimes, like beating confessions out of people. That's what giving the 3rd degree.
Not great. I'm glad I haven't heard of it.
So an understanding of the nature and setting of the in-custody interrogation, says the Supreme Court, is essential to the way and the reasoning for their decision. So they said that there's difficulty in depicting what transpires at such interrogations, and that stems from the fact that in this country, they have largely taken place incommunicado, which is a big word like mayonnaise, that means not able or allowed to communicate with other people. So it's done in private. It's done in secret, right?
Not great.
Supreme Court's kind of like, we don't really know what exactly goes on during custodial interrogations.
But they don't like it.
Well, we're going to get into why. So from extensive factual studies undertaken in the 1930s, including a famous Wickersham report to Congress by a presidential commission, it was clear that police violence in the 3rd degree giving somebody the third degree flourished at that time, way back in the 1930s. So
I can only imagine what that was like back then.
Oh, man, right? So, in a series of cases decided by the Supreme Court after those studies, it was pretty clear that the police had resorted to physical brutality and to sustained and protracted questioning incommunicado in order to extort confessions out of people. So, but then they go on a little bit further and they say, hey, the Commission on Civil Rights in 1961 found much evidence to indicate that some policemen still resort to physical force to obtain confession. And quoting the Wickersham Commission, the Supreme Court noted that the third degree, quote, brutalizes the police, hardens the prisoner against society, and lowers the esteem in which the administration of justice is held by the public.
I think you could say that. All right.
Yeah, exactly. So it's a real rough start.
Yeah.
Now, the Supreme Court acknowledges that the vast majority of that from the time of this decision was done in the past, right? So they say, quote, again, we stress that the modern practice of in custody interrogation is psychologically rather than physically oriented. As we have stated before, the court has recognized that coercion can be mental as well as physical, and that the blood of the accused is not the only hallmark of an unconstitutional inquisition. So they're saying, hey, let's look at custodial interrogations overall. Back in the day, you used to beat confessions out of people, and that's not cool. But currently, it is way more of a psychological thing than it is a physical thing, and that can still be a problem when it comes to the Constitution. Interrogation still takes place in privacy. Privacy results in secrecy, and this, in turn, results in a gap in our knowledge as to what, in fact, goes on in interrogation rooms. So they freely admit, they're like, we don't really know what's going on.
Yeah.
So what are we going to do? We're going to read police manuals.
Oh, boy.
It doesn't help us. So
a police manual from when?
From the time, it was
the
current.
60s?
Yeah, from the 60s. So they're like, all right, so we don't know exactly what's going on, so let's see what we're teaching the police. By reviewing police manuals, the court describes how the interrogation environment is engineered to break the suspect's will. Quote, the principal psychological factor contributing to a successful interrogation is privacy, being alone with a person under interrogation. Officers are told to assume guilt as fact, minimize wrongdoing, and use persistence.
Yikes.
Quote from the manual, he must dominate his subject and overwhelm him with his inexorable will. And so they keep going through the police manuals. And in addition to it being very psychologically stressful on the suspect, they note a whole lot of deceptive methods that were taught at the time. So these tactics include the Mutt and Jeff. Have you ever heard of that?
Oh, like the last term, no.
No, I had never heard of Mutt and Jeff before. But it's good cop, bad cop.
No.
So good cop, bad cop was taught in the police manuals as the time. I'd never heard it called Mutt and Jeff. I don't know where that
show
comes from. I don't know. And the manuals also listed something called the reverse lineup.
The reverse lineup.
The reverse lineup. Are you familiar with what that is?
I've done a folder system. Does that count?
No. So this was very interesting to me. I had never heard of this, and it's super clever, but also not cool.
Oh boy.
So what they did is they would put the suspect in a lineup, but then they would have a whole bunch of fake witnesses walk by and identify him.
Just like people from the police department?
Just random people.
Oh boy.
And so they would all pick him out, and so put this tremendous amount of pressure on that person.
Oh man. 15 people have identified you. You ready to confess?
Exactly. But you got to think though, like this is back in the day of actual like lineups. So they are well aware that these people are picking them over and over and over. I
must be screwed.
Yeah, trying to get confessions out of people. And the court goes on. So they highlight how officers were trained to discourage suspects from using their legal protections.
Oh, great.
For example, discouraging legal counsel. Interrogators suggest, quote, that the subject save himself or his family the expense of any such professional service, particularly if you're innocent. So, hey, dude, you don't need a lawyer.
You got nothing to hide.
Yeah, you got nothing to hide. If you're innocent, you don't need to hire a lawyer. Save your family the expense, man. Like that was taught at the time. You're going to love this one too.
I don't think love is probably a part of it.
If a suspect remains silent, officers are told to imply guilt. quote, it was actually longer than this. I pared it down a little bit, but you get the point. So, quote, suppose you were in my shoes and I were in yours, and you called me to ask me about this, and I told you, I don't want to answer any of your questions. Well, you would think that I had something to hide, and you would probably be right.
Mm.
That's exactly what I'll have to think about you if you refuse to answer my questions. So, yeah, didn't really help us very much. So the court was like, look, the mere environment of custodial interrogation in a police station creates, quote, a compulsion that can violate the Fifth Amendment. So they say that it is obvious that such an interrogation environment is created for no purpose other than to subjugate the individual to the will of his examiner. The atmosphere
to
carries...
get dominated by his examiner.
Pretty much, right? The atmosphere carries its own badge of intimidation. To be sure, again, they hammer this point home. This is not physical intimidation, but it is equally destructive of human dignity.
And abusive.
Yes, that is a good summary of what old Earl is saying in his opinion of the manner in which police custodial interrogations were conducted at the time. It's important to mention that, right? This is an old case. It's 60 years old.
I guess this is why the uphill battle of police trust has existed for so
100%,
long.
right?
So I guess I hadn't really noticed. I'd be learning about that in case law.
Yeah, I know, right? And I mean, the Supreme Court at this point in time took some pretty strong stances.
So you guys are really bad.
Yeah. So the whole point of all of this, when they go over the historical context, when they go over what the police manuals were teaching police at the time, they culminate that by saying, look, unless adequate protective devices are employed to dispel the compulsion inherent in custodial surroundings, no statement obtained from the defendant can truly be the product of his own free choice. So they're saying all of this, you have to have safeguards, or else there's no way that this is going to be a freely given statement. So in the second section, so they set the historical context right off the rip. In the second section, they talk about how the right against self-incrimination is a privilege, and that those protections must extend to modern police interrogations. So there was a bit of an argument at a time that, hey, when the Constitution was written, they were only talking about the right against self-incrimination in a courtroom setting. And so section 2 is the Supreme Court saying, no, that totally applies to police interrogations as well. And they start off by saying, look, the privilege against self-incrimination was a hard-won right.
Hard one.
Yes. And it was, it's been something that's been enshrined for a really, really long time. So they trace it all the way back to the case of John Lilburn in 1637, which I know you love when we go way back in history.
Common law, as I've learned.
Well, yeah. So this is English common law before American common law. So the privilege's origins are linked to the 1637 trial of John Lilburn, who refused something called the Star Chamber Oath, declaring that no man's conscience ought to be racked by oaths imposed to answer to questions concerning himself in matters criminal. It's very 1637 English wordy.
Yeah, that's the typical case law I wouldn't be reading.
Yeah, exactly. So a Star Chamber Oath was kind of a jacked up thing that they used to do to suspects in criminal cases back in the day. So it was an oath that they had to take before testifying at all that created a pretty cruel trilemma for them. So the oath that they took gave them 3 options, right? Because they were forced to take
options.
Well, they were forced to take an oath saying that they were going to swear to answer all questions truthfully before they knew what the charges were or what the questions were. Right? So this created a cruel trilemma, because if they took that oath ahead of time, there was essentially only 3 options, right? They could lie and commit perjury. They could answer and incriminate themselves, or they could refuse to answer and they'd be held in contempt of court.
Interesting.
So
that's one way to do it.
Yeah. So like they would make them take this oath ahead of time, and those were the only 3 options. Well, so old John Lilburn said, no,
I don't like that.
Doing that
I don't love that.
Yeah, I don't love it. So that is kind of what kicked off the privilege of enshrining the right against self-incrimination. Started way back then. And the founders were weary of silent approaches and slight deviations from legal modes of procedure, and they elevated the privilege to a constitutional status as broad as the mischief against which it seeks to guard. So, because it's pretty broad, right? It says, hey, nobody has to be compelled to self-incriminate themselves, which is super broad because they're saying, hey, there's all kinds of tricks and things. That's also broad. So the scope of this right needs to be broad as well. And the court defines the privilege against self-incrimination as, quote, an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So the court emphasized that the accusatory system, which is how our legal system works, spoiler alert, is you have two sides arguing against each other. They're saying that it requires the government to prove its case independently. The government must shoulder the entire load and produce the evidence against him by his own independent labors, rather than by cruel, simple expedient of compelling it from his own mouth. So he's saying, look, it's your job to prove that people are guilty.
Yeah.
You can't always just cut to the chase and make them confess to you, right?
Because apparently that's all we did back in the old days.
Yeah, right.
Confess your sins.
Yeah. So the privilege against self-incrimination, again, every time I say the privilege, it's going to be the privilege against self-incrimination. But it's only truly honored when a person is guaranteed the right to remain silent unless he chooses to speak in the unfettered exercise of his own will. So the court fully rejected the idea that the Fifth Amendment only applies in a courtroom. And one of the main reasons they said for that is like, look, the pressure of a police station can be even more intense than the pressure of a courtroom.
Yeah, that makes sense.
Yeah, we are satisfied by all the principles embodied in the privilege applied to informal compulsion exerted by law enforcement officers during in-custody questioning. So they squash that. Like, this 100% applies to custodial interrogation. They say, as a practical matter, the compulsion to speak in the isolated setting of a police station may well be greater than in the courts, where there are often impartial observers to guard against intimidation or trickery. So again, they go back to those police manuals, right? So they're saying none of that shenanigans is going to happen right in the middle of the courtroom. So that custodial interrogation back at the police station might actually have more pressure than the courtroom.
You've got no witnesses, apparently.
Yeah, right? Because it's all done in private, incommunicado, right? The court identifies the lack of rights awareness and the absence of an attorney as
because they didn't have Cuffs and Case Law podcast back then.
Right. Yeah, that's true. But lack of rights awareness and the absence of an attorney are the primary factors leading to compelled confessions. So in previous cases like Escobedo that we talked about earlier, the court found that the choice on his part to speak to the police was not made knowingly or competently because they failed to apprise him of his rights. So they're saying, look, in these sort of situations, having an attorney present is a safeguard for that individual who may not be familiar with their rights.
Yeah.
Quote, the presence of counsel would be the adequate protection device necessary to make the process of police interrogation conform to the dictates of the privilege. So
definitely don't understand that one.
It says just having an attorney there would make sure that the police don't make this guy incriminate himself against his own will, right?
Yeah.
If he chooses to do so freely and voluntarily and intelligently, so be it, right? But if they're trying to do some tricks and trying to stack the deck way against this person, just having an attorney there is going to make sure that this guy's rights aren't violated.
If they're good at their job.
Correct, yeah. Without these protections, quote, all the careful safeguards erected around the giving of testimony would become empty formalities because the most damaging evidence, the confession, would have already been obtained at the unsupervised pleasure of the police. So, again, pretty strong words there.
Yeah.
So, start by setting the historical context, and then they go into that as far as the reasoning. But that sums up Section 2 of why they justified this. All right, so that concludes Section 2. In Section 3, this is where they actually outline the specific procedural safeguards that we now know as Miranda Rights. And this is where they say that these have to be employed to protect the Fifth Amendment privilege during custodial interrogations. So the court asserts that because the interrogation environment is inherently compelling, specific warnings are an absolute prerequisite to any questioning. At the onset, if a person in custody is to be subjected to interrogation, he must first be informed in clear and unequivocal terms that he has the right to remain silent. The warning of the right to remain silent must be accompanied by the explanation that anything said can and will be used against the individual in court.
That sounds familiar.
Starting to sound familiar. This whole section should sound familiar to you.
Better.
Yep. And the warning serves to make the individual acutely aware that he is faced with a phase of the adversary system, that he is not
the adversary system.
Exactly, right? Because he is not in the presence of other people acting solely in his interest.
Yeah.
So it's a warning to put them on guard of like, hey, it's me against you. This is an accusatory system here. I'm not your buddy. I'm not your friend. In this specific set of circumstances, right? I am conducting this interrogation to get information that will be used against you. They want that made abundantly clear to that person. The court emphasizes that mere warning of silence is insufficient. A suspect must have access to legal expertise to protect their rights in this high-pressure setting, right? So, quote, the need for counsel comprehends not merely a right to consult with counsel prior to questioning, but also to have that counsel present during the questioning if the defendant so desires. The need for counsel in order to protect the privilege exists for the indigent as well as the affluent. If he is indigent, a lawyer will be appointed to represent him. So they're saying, look, that poor people, rich people have these rights. It doesn't matter. So if they cannot afford an attorney, then a lawyer will be appointed to represent him. And the court outright rejected the idea that a suspect must specifically ask for a lawyer before interrogation. The defendant who does not ask for counsel is the very defendant who most needs counsel. So next they go into the procedures for invoking their rights. The court provided a clear mandate for police conduct once a suspect chooses to exercise their constitutional protections. So, quote, if the individual indicates in any manner that he wishes to remain silent, the interrogation must cease. If the individual states that he wants an attorney, the interrogation must cease until an attorney is present. And if the police continue questioning without an attorney and obtain a statement, the legal burden shifts heavily to the state. So they're saying you can't do that if they specifically ask it.
Yep.
But if the person does not specifically ask to have an attorney present and there's not one there while you're doing your questioning, okay, now there's a heavy burden that rests on the government to demonstrate that this defendant knowingly and intelligently waived his privilege. And a valid waiver will not be presumed simply from the silence of the accused. Any evidence that the accused was threatened, tricked, or cajoled into a waiver will, of course, show that the defendant did not voluntarily waive his privilege. So, next, the court clarified that these rules only apply to all incriminating statements, but they don't stop traditional police work or voluntary confessions. These rules apply to confessions, admissions, and even exculpatory statements, as these are often used to prove guilt by implication, right? But general on-the-scene questioning as to facts surrounding a crime or other general questioning of citizens in the fact-finding process is not affected by our holding. So they're like, you can still talk to people. You can still interview people. You have to do that in the course of your job. We are specifically talking about custodial interrogations here. And they also say, look, that if somebody wants to make a voluntary confession, then this doesn't affect that at all either. There is no requirement that a police stop a person who enters a police station and says that he wants to confess.
Mm-hmm.
Volunteered statements of any kind are not barred by the Fifth Amendment. So they're saying, look, just because we've outlined these
you're free to confess too.
Yeah, you're free to confess, and police are still free to talk to people.
Yeah.
It's just that if it's in the context of a custodial interrogation, there are rules.
Yeah.
And these rules are that you have to tell everybody everything up front. That's all that it's saying.
Mm-hmm.
So that third section is real important. That's where it actually establishes the Miranda Rights.
Tells you exactly what to do.
Exactly. All right. So on to section 4 of their reasoning for the decisions that they're making here.
We're getting there.
Yeah, I know, right? So what this section talks about is, hey, there's a perceived need for confessions, and that doesn't outweigh the Fifth Amendment here. So the court, excuse me, the court,
hydration's important.
Yeah,
maybe you should have some.
Yeah, let me start here.
Yeah, apparently all you could do during this time was in police work was get confessions, and if you didn't have a confession, that was it.
Humorously, you just summed up the fourth section of their justification here. They're like, no, Like you can still get confession or you can still get convictions out of people.
Oh,
All right. So the court rejected the argument that the necessity of police work outweighs the Fifth Amendment. So, quote, the Constitution has prescribed the rights of the individual when confronted with the power of government. That right cannot be abridged. So, quoting another justice, they said,
mhm.
if the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. So,
Don't love that.
yeah, no. So the quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of its criminal law. The court then defends the presence of having counsel as a fundamental component of justice, not an obstacle to it. An attorney is merely exercising the good professional judgment that he has been taught. This is not cause for considering the attorney a menace to law enforcement. It kind of feels that way.
Adversarial.
Yeah, right. Well, it is, right? But he's not a
No.
menace. He might be a menace to the law enforcement officers, but not to the enforcement of the law, is what
No.
I'm saying. So the attorney is, quote, carrying out what he is sworn to do under his oath to protect, to the extent of his ability, the rights of his client. And then next,
Wonder what the lawyer handbooks were back then.
I don't know.
They say dominate the police officer.
I guess, right? Make the police officer question everything he thinks he knows about everything. So then the court argues that law enforcement can be effective without relying on compelled statements. And they point to the 4 cases that they're talking about here as evidence that, hey, you guys didn't even need confessions. Quote,
so you had quite a lot of cases.
That's what it is, right? Quote, the cases before us present graphic examples of the overstatement of the, quote, need for confessions. In each case, authorities conducted interrogations ranging up to 5 days, despite the presence
still ridiculous
of considerable evidence against each defendant. So they're like, you questioned these dudes for 5 days, and there's all kinds of evidence against these guys.
No.
Yet you went through all this rigmarole to get a confession out of them when you had this abundance of evidence on the side. The court notes that arrests for interrogation subject large numbers of innocent people to detention, citing one of these cases where 4 individuals were jailed for 5 days until a third party confessed.
For guilty by association.
Yeah, exactly.
Being in the wrong place at the wrong time.
Despite there being no evidence to convict them of any crime. So there they are specifically talking about the case of, let's see here, which one was that? Yeah, California v. Stewart, where they arrested him and everybody else in his household. They're specifically talking about that case. Like, no. Even
though they obviously had gotten evidence to lead him to that house.
To the house, absolutely. Yeah, and to Stewart, absolutely. Yeah. But not to everybody else in the house. So they say, look, arrests for investigation subject large numbers of people, innocent people, to detention. So they go on to say, look, again, in proving the point that there's no need for confessions in every single case, and that this is nothing extreme that we're requiring you to do. They're like, look over at the FBI. The FBI pretty much does this already. So they said the FBI has long followed a pattern of warnings and respect for the rights of an individual that is consistent with the procedure that we delineate today. FBI is pretty much already doing this. They still solve crimes. So stop whining. That's pretty much what
and they did in one of these cases.
Yes. So the standard warning long given by special agents is that the person has the right to say nothing and the right to counsel. And any statement he does make may be used against him in court. So it's simplified, but it's pretty darn close to exactly what they laid out in this case.
Yeah.
Like, FBI is still getting convictions, so you guys can too. Appears to have no marked detrimental effect on criminal law enforcement. So you can still do your thing. And
even at the federal level.
Yes. Speaking of the federal level, they talk about Congress here in a second. And they say, look, we're all for legislative reform, but the protection of constitutional rights is ultimately a matter for the judiciary. Congress,
stay out of our way.
Pretty much. Congress and the states are free to develop their own safeguards so long as they are fully as effective as the safeguards we listed above. And where rights are secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate. It's a big word like mayonnaise. That means repeal or do away with them. So where rights are secured by the Constitution, when we're talking about those, There's no rulemaking. There's no law that can repeal or do away with those rights.
Don't touch our Constitution.
Pretty much, yeah. Stay away. Stay in your lane. This is our lane.
We will interpret this, not you.
Yeah, if you guys want to be more, like, if you guys want to develop your own thing, cool, so long as it fully encompasses what we just laid out. Judicial problems of the constitutional dimension have been involved decade by decade. Quote, that was our responsibility when Escobedo was before us, and it was our responsibility today. All right, man, that brings us to the last section here in the justification for their decision. And in this section, they're like, hey, we just applied all these newly defined constitutional principles, but we haven't talked about any of the 4 cases specifically that brought this here.
We have 4 parts of beating you up.
Yeah, exactly. So here we go. We're now going to talk about the 4 cases that were all brought together, combined into what we now know as Miranda
this new
v.
standard.
Arizona. Exactly. So they start with Miranda v. Arizona.
Naturally.
And they're like, all right, old Ernesto Miranda, it is clear that Miranda was not in any way apprised of his right to consult with an attorney or to have one present during interrogation. The court rejected the typed paragraph at the top of his confession, claiming that he had full knowledge of his rights, stating that it does not approach the knowing and intelligent waiver required to relinquish constitutional rights. So his confession's no good. Moving on to Viniera v. New York. Michael Viniera, as we recall, was interrogated by a detective and later the...
and everywhere in the NYPD.
Yeah, they just bounced. And then the assistant district attorney. And at the trial for Viniera, the trial court judge told the jury that the law doesn't say that the confession is void or invalid because the police officer didn't advise the defendant he has rights. And the Supreme Court said, well, we just did. So they ruled that old Viniera was not effectively apprised of his Fifth Amendment privilege or of his right to have
steal as many dresses as he wants
or his right to have counsel present, and his statements are inadmissible. Another one shot down. So we're 0 for 2 so far.
Not great.
Not doing great. All right, moving over to Westover v. United States. So as we recall, Carl Westover was interrogated by the police for 14 hours without warnings. And then he was handed over to the FBI, who gave warnings before obtaining a confession. And the court said, from Westover's point of view, the warnings came at the end of the interrogation process. In these circumstances, an intelligent waiver of constitutional rights cannot be assumed. The federal authorities were the beneficiaries of the pressure that was applied by the local in-custody interrogation that happened beforehand. So in these circumstances, the giving of warnings alone was not sufficient to protect the privilege.
0 for 3.
Yeah, 0 for 3. All right, so now we get into the case of California v. Stewart.
I'm sure they're going to love this one.
Well, remember, this is the only one where in the process of making its way to the Supreme Court, this is the only one that deviated. So let's see what they say here. So if you remember,
California said,
if you remember, Mr. Stewart was held in isolation. He was interrogated 9 separate times over 5 days before finally confessing.
9 times over 6 days.
5 days.
Close enough.
The court said Stewart's steadfast denial through 8 of the 9 interrogations over a period of 5 days is subject to no other construction than that he was compelled by persistent interrogation to forego his Fifth Amendment privilege. Yeah. We will not presume that the defendant has been effectively apprised of his rights on a record that does not show that any warnings had been given. So, in total, the Supreme Court, reversed the convictions of Miranda. Here I am committing.
No, boy.
In total,
Miranda.
In total, the Supreme Court reversed the convictions of Miranda, Viniera, and Westover, and they affirmed the California Supreme Court's reversal of Stewart's conviction. So
affirm their denial.
No, that doesn't work in this case. It usually works, but it didn't work in this case. So they said, look, statements were obtained from the defendants under circumstances that do not meet the constitutional standards for the protection of the privilege. So that's it, man. This is it. This is a big one. This is a huge case that established the Miranda warnings. Every single cop is taught about Miranda warnings, right? This is a big deal.
Yep.
And it's super important. This completely changed the landscape of law enforcement and how in custody interrogations are to be conducted by the police. So much so, like, have you ever seen those little cards?
Oh yeah, I was given one early on in
Were you?
FTO. Yep.
Yeah. So much so that those
Turns out it didn't help me because I hate reading,
turns
so I
out
just had to learn it.
there's a lot of cops that carry around the Miranda warnings on a card, and those warnings specifically say exactly what the Supreme Court laid out.
So that's not the problem. The problem is knowing when to say it.
Yep. Absolutely.
And then the lawyer stuff later on, once you get them into a room, they start talking.
Yeah.
Or don't start talking.
Exactly.
And you got to remember.
Yep. Yep. So this is a big important case, man, and I'll just, because it is such a heavy hitting case, I'll just go back through and I will read some of the highlights again. All right. So forgive me, I'm going to specifically read this because this is important, and I want to make sure that I get this verbatimly correct. All right.
So you two also get this correct.
Correct.
And you hear it again. So it is nailed home.
All right. In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privilege must be observed. The person in custody must, prior to the interrogation, be clearly informed that he has the right to remain silent, and that anything he say will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have a lawyer present with him during the interrogation, and that if he is indigent, a lawyer will be appointed to represent him. If the individual indicates prior to or during questioning that he wishes to remain silent, the interrogation must cease. If he states that he wants an attorney, the questioning must cease until an attorney is present. When an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his right to the counsel. Where the individual answers some questions during custody interrogation, he has not waived his privilege and may invoke his right to remain silent thereafter. The warnings required and the waiver needed are, in the absence of a fully effective equivalent, prerequisites to the admissibility of any statement, inculpatory or exculpatory, made by the defendant. So, there it is. Those are the Miranda warnings.
That would be the punchline.
That's the punchline. These are Miranda warnings. These is where they come from. It's super important, super foundational. And in this specific case, 4 separate cases were brought to the Supreme Court, and they shot them all down. So
a lot of good police work down the drain.
Yeah, well, at least down the drain to be remanded back to the lower courts, right?
Except for the confession part.
Yeah, that's gone. That's way gone. So that's it, Dave. That's what we learned in Miranda v. Arizona. And I know there was a lot. Thank you for bearing with us. I know there was a lot that we covered there. But again, this is a foundational, this is a landmark case. This is extremely important. It altered the way that policing was done. This is something that is stressed to new officers of, hey, you have to know when Miranda applies, and you have to apply it correctly. You have to memorize these specific things, because this is exactly what the Supreme Court said.
If you screw it up, everything's gone.
Yeah, everything's gone.
And you don't need a confession. You need to do good police work.
Correct. That's what the Supreme Court said is, hey, your job's not over because you have to warn people of their rights. It's pretty much.
You weren't held by it. The only thing you could do.
Yep. So,
or play games with them.
Right. Now,
or torture them.
Since this is such a big case and this is such an important case, I would like to go over just the highlights of some follow-on cases. Now, this I will, but this does not preclude any of these from having their own episodes in the future.
Yep.
Just now that we're talking about Miranda, these cases are further follow-on cases to Miranda. So I want to make sure that there's some context there too.
Because the context matters.
It sure does. And for you, Dave, I'm going to go over these in chronological order.
Wow. Thank you.
Again, just for the reminder, Miranda was 1966.
Like we're going around to watch.
Yeah, nice. Well done.
Speaking of, it matches the...
Gosh, we're an hour and 7 minutes in before you brought it up, but you still managed. I'm proud of you.
I did.
Thank you. I appreciate that.
It matches the microphones tonight.
It does. Yeah, it kind of does. It looks good.
What does that one do?
This one tells the time.
All right. Does it make it go through case law faster?
It doesn't. No.
Okay.
So
let's do it.
Buckle up. All right. So again, Miranda v. Arizona is 1966. That case requires that police inform suspects of the rights before custodial interrogation, and unwarned statements are generally inadmissible.
No.
Next one was Harris v. New York in 1971. Statements obtained without proper Miranda warnings may be inadmissible in the prosecution's main case, but they can be used to impeach or challenge the defendant's credibility if they testify. Next one is Doyle v. Ohio in 1976. Prosecutors cannot use a defendant's post-Miranda silence against them.
Oh, boy.
Yep, I had to make it all the way.
You were quiet.
By the way, I failed to mention this. Everything that I'm about to tell you is from the United States Supreme Court. So that made it all the way to the United States Supreme Court.
I'm shocked by that.
3 years later, in 1979, we have North Carolina v. Butler. Miranda rights can be waived implicitly through conduct. The Supreme Court held that a waiver of rights does not have to be explicit or in writing to be valid. 1 year later, Rhode Island v. Innis. This case defines interrogation as words or actions likely to elicit an incriminating response. Officers talked amongst themselves about a missing shotgun and the danger it posed to children. This one was covered in my police academy. Do you remember this?
I don't remember this, no.
So they're looking for a gun tied to a crime.
Mhm.
They got the guy in the back seat of the detective's car, and two detectives, they're not talking to him. It's like you and I, and we got a bad guy in the back, and they're like, man, I know there's a shotgun out there. Can you imagine if a kid picked up that shotgun?
Well, you just think of the children, sir.
Yeah, what if the kid accidentally shot himself? And you're like, man, that would be horrible. And he's like, fine, the shotgun's over there in the woods. And they're like, gotcha. That was Rhode Island v. Innis in 1980. And the Supreme Court was like, that's interrogation. Next, again, 1 year later, Edwards v. Arizona, because we love Arizona.
You love Arizona.
I don't. Once a suspect requests counsel, interrogation must stop until a lawyer is present. Berkheimer versus McCarty. This one is probably going to be its own cuffs and case law episode in the future. But as far as Miranda, what you need to know is that that partially ruled that routine traffic stops are not considered custody for Miranda purposes. Also in 1984, it was a busy year. New York versus Quarles ensures the public safety exception to Miranda. So this one was actually gone over in my police academy as well, way back in the day. If you rob a place and you rob it with a gun and I'm on scene and I chase you and I tackle you and I'm like, where's the gun? And you say, it's over there. That's admissible because it was a public safety reason for me to find that gun right now.
Because we didn't want the children to find it.
Right. So, again,
that would be an interesting line on that case as well.
New York v. Quarles. All right. The next one is Oregon versus Elstad in 1985. These are like right in a row.
Yeah.
Supreme Court held that a voluntary, unwarned statement does not automatically invalidate a later warned confession. So if you flat out make a statement before I get to warnings, and then I warn you, and then you confess, it doesn't automatically invalidate it. Moran v. Burbine in 1986. A waiver is valid if knowing and voluntary, even without full external information. So this one's interesting. This one is close to one of the four cases in Miranda, but there's a huge difference. A suspect's waiver of his Miranda rights is valid even if police fail to inform them that an attorney is trying to reach them.
Mm.
So we may go into that case too, because that's an interesting one. Davis v. United States in 1994. Invocation of the right to counsel must be clear and unambiguous. Quote, maybe I should talk to a lawyer, close quote, was not a clear request. So if they're like, man, maybe I should talk to a lawyer, that is not the same as I want to talk to a lawyer.
It has to be a declaration.
Yes.
Not a question.
Correct. It must be clear.
Should I have an attorney? Well, I can't advise you of your legal rights.
Correct. It needs to be clear and unambiguous. Dickerson v. United States in the year 2000 confirmed that Miranda is a constitutional rule and Congress can't override it.
I feel like Earl said that.
He sure did.
He said, don't even try it. And they said, we're going to try it.
Yeah, and they tried it 44 years later. 34 years
But
later.
like Earl's not paying attention anymore.
United States versus Patain in 2004. Physical evidence derived from unworn statements may still be admissible. The court emphasized that Miranda is a prophylactic rule designed to protect Fifth Amendment rights, not to exclude evidence derived from voluntary actions. It's an interesting one. Missouri versus Siebert, also in 2004, invalidates the deliberate question first, warn later interrogation
Oh
strategies.
boy.
All the way up in 2004, man.
They were still trying it.
Still trying.
Someone found a bad manual.
Yep, can't do it. And Burgess v. Tompkins in 2010, silence alone is not enough. Suspects must explicitly invoke their right to remain silent. I'm not talking to you. Tompkins, who was the guy in this case, remained mostly silent for 2.5 hours, but didn't explicitly say, I'm not talking to you. Later, after 2.5 hours, he eventually responded to questions, and the court ruled that his statements were voluntarily admissible. He had been warned. So those are quite a few cases. I know I blitzed through them, but they're so closely related to Miranda. And since this is a big and important episode, I wanted to make sure that I gave a little bit of follow-on right over an additional 40 years of Supreme Court case law.
No, it's a great application too.
Yeah, exactly.
They
right.
make a ruling and then you got to apply it over several cases.
Turns out case law keeps rolling, right? So just because it was foundational in 1966 doesn't mean that a whole bunch of questions haven't been answered since, like we just went over, right? So it's important to know that too. So I wanted to go through and highlight some of the more important ones. Again, that's not all of them by any means. There's a ton more Miranda cases out there. So please feel free to do your own research. And some of these cases I would really like to go over in individual cuffs and case law episodes because
we'll get there.
Yeah, we'll get there eventually. But in order for us to keep getting there, we need you guys to keep watching, keep telling your friends, and keep engaging with the channel. That's so huge for us. And we're very appreciative to you guys for that. But Dave, that's all I got for us today, buddy. You got anything else?
Drink more water. Hydration is important.
Yeah, that's also true. And mobility training is strength training. So that's all I got. Thanks, guys.
Don't move so fast.